Hello and welcome to Candid Conversation. Our guest this week is Justice A.P. Shah. He is the former chairman of Law Commission. He's just stepped down as chairman of the Law Commission. Today we will talk to him about a report of the Law Commission which has recommended that death penalty be done away with eventually in India and for now be retained only for terrorism related offences and waging war against the country. Towards the end we will also talk to him about a committee which he headed, which has recommended that MAT may not be levied retrospectively on FIIs and FPIs before April 1, 2015. I welcome you, Justice Shah, to Candid Conversation. Let's begin with the report of the Law Commission on death penalty. I would want to start by asking you that why has a distinction been drawn as far as terrorism-related offences and waging war against the country is concerned? Because the recommendation is that you abolish it eventually, but for now just keep it for terrorism-related offences and waging war against the country.
The Commission has specifically recorded that the aim should be, ultimate aim should be abolition of death penalty for all offences. But we felt that this needs to be done in a phase-wise manner. Why phase-wise manner? Because there is serious reservation about the terror-related offences amongst the lawmakers. So perhaps we thought that it should be done gradually, as it was done in UK. Death penalty was abolished in respect of certain offences initially. Then UK retained the death penalty only for specific offences like waging war against the state, terror-related offences, and then finally the death penalty was abolished for all offences. But I wish to make it clear that the Commission has not made a distinction between the ordinary offences and terror-related offences. We have just suggested a way towards the abolition of the death penalty. Now, terror-related offences also should be to abolish the death penalty in respect of those offences as well. And in our report we have explained that really death penalty doesn't work as a deterrent for terrorists.
We'll come to that. But since we were talking about terror-related offences and waging war against the country, and you talked about the UK model, on the basis of which perhaps partly the Law Commission would have suggested that it be retained for these offences, is it also because this concerns the integrity and sovereignty of the country?
No, there are concerns expressed about the national security. Of course, the concerns about the integrity and the other aspects have to be kept in mind, but it's the view of the Commission that even other countries look at I can give some examples. I mean, we have given example of Israel,
absolutely,
then Sri Lanka, Nepal. Now there are many countries which faced problems of terrorism, insurgency, but the death penalty has not been. There are no executions in these countries. In Sri Lanka, there is no execution for last 30 years. The last execution in Israel was in 60s. Eichmann, he was executed, the Nazi criminal. So thereafter, there is no execution. There is no judicial execution, though the death penalty remained on the statute. So it's my view that merely because the death penalty is abolished in respect of terror-related offence does not mean that India would be seen as a weak state. That's not the correct perspective.
Okay.
But since the Commission felt that the time is not ripe for the abolition of the death penalty for all the offences completely, therefore we suggested a phase-wise abolition of the death penalty.
You referred to the argument which is given of deterrence, but before I come to that, in many areas in the report you have mentioned, or the Law Commission has mentioned, the Bachchan Singh judgment of 1980, which laid out the principle of rarest of rare. Had that principle of rarest of rare been followed in letter and spirit, would the situation have arisen that the Law Commission would have had to recommend abolition of death penalty?
All right. Let me go back to the colonial days when death sentence was a rule and life sentence was an exception. Then if the judge has to give life sentence, then he has to give special reasons for that. So this position changed in 1955. The requirement of giving reasons was done away with. Then 73 there was amendment by which special reasons were required to be given for awarding death penalty. And in 1980, the Bachan Singh laid down the criteria of rarest of rare. The reason was the abiding concern for human life, and the court felt that it should be done only in exceptional cases where all other options are foreclosed. These are the words used in and they said it should be done in the rarest of rare. But what happened after Bachan Singh is, and particularly in last decade, there are voices raised by the judges themselves that this rarest of the rare principle has not worked. The death penalty
has it not worked because exacting legal standards were not followed by the judiciary?
No, it's not question of really following the certain legal standards. See, it is become just centric.
Isn't this at the discretion of the courts? Any judgment is at the discretion of the courts.
There has to be discretion, and therefore the principles are laid down in Bachan Singh that you consider the aggravating and mitigating circumstances and then decide whether to award the death penalty if all other options are foreclosed. But the judges themselves are complaining that it has become just centric, it has become arbitrary, it is unprincipled. I mean, why in a particular case death penalty is awarded and why it is not awarded in a similar case? It depends upon the personal predilection of the judge. This is
can there be a basis of jurisprudence that can be arrived at for rarest of rare principle?
No, I feel that this is what our conclusion is that we cannot have a death penalty system which is completely free of arbitrariness. This element of arbitrariness and freakishness is bound to be there, because you see, you have two options, like the olden days, that the death penalty is a rule. In every case of say 302, death penalty is to be awarded, or you give the discretion to the judges.
Right.
And this discretion part has not really worked at all.
But as far as heinous crimes are concerned, where the evidence is beyond doubt about the complicity of a particular person into a crime, why should rarest of rare principle not apply there? Because the room of arbitrariness will be minimal or nil nearly.
See, there are various aspects. For example, in Bachan Singh, the court said that the court shall take, the judge shall take into consideration the circumstances of the case as well as circumstances of the accused. For example, young age of the accused. It's a relevant circumstance, but you will find that there are a set of cases, say rape and murder, where the court has taken cognizance of the young age of the accused and commuted the death sentence to life sentence. But there are other cases where the judges have taken a view that though the accused is young, death penalty should be awarded. And it's a very complex issue. It's not that that there is some set pattern which can be applied, and then a decision can be taken either to send the accused to gallows or no. There are for example, the Supreme Court itself has acknowledged that in 16 out of 69 cases, there's almost 23% of the cases, the death penalty was wrongly awarded to the accused.
So, but one of the dissent notes says that to err is human, everyone is infallible.
Oh, you are right. As a principle, I am not disputing that, because I don't see that. But please make a distinction between the death sentence and a life sentence. Death sentence is final. It is irreversible. What happens when an error is committed by the judge? I can give you several examples.
But there are several layers that are there. I mean, first the Sessions Court or the lower court would give a judgment, then the High Court would confirm it, then the Supreme Court would confirm it, and there's this executive power of presidential pardon as well.
Let me first talk about the three layers in the judiciary. In spite of the three layers in the judiciary, you will find, I mean, that the application of the death penalty is very disparate. For example, take Akshardham terrorist attack. Now the trial court, a judicially trained mind of a judge comes to the conclusion that the accused is guilty and death penalty is awarded. Two judges of the High Court, they confirm the death sentence. And finally, what the Supreme Court says that the entire evidence was concocted by Gujarat police. It's a fabricated case. Now, fortunately, it is discovered in this, and the court granted relief. But there will be cases. We have quoted several examples where the mistakes are committed not only by the trial judiciary, but or the High Court, but also by the Supreme Court. As I mentioned just now, that in 16 cases the death penalty was wrongly awarded. Now, what happens in cases? I can give you another example where the trial court and the High Court acquitted the accused, and then in the Supreme Court, he was convicted, and death penalty was awarded to him. Now, the international law requires that you should have an appeal against an award or death penalty. But if the death penalty is awarded by the Supreme Court in the first place, where is the question of appeal? Now, if you see the recent cases, you will find that in several cases the Supreme Court itself has doubted the death penalty given in other cases. I mean, that's very apparent. So and apart from the arbitrariness, one more aspect which has been noticed by the Commission is the discriminatory nature of the death penalty.
Okay, we'll take a break at this point in time. You're watching Candid Conversation with Justice A.P. Shah. Welcome back. You're watching Candid Conversation. Our guest this week is Justice A.P. Shah, former chairman of the Law Commission. Justice Shah, before the break, we were talking about various aspects on the death penalty, on the basis of which the Law Commission has given its report. Earlier, there was a point that was raised by you of deterrence value. The Supreme Court in a judgment had said that there is perhaps no empirical evidence that is there that connects the death penalty with deterrence. But the Supreme Court had also said that you just can't point out how many people were deterred by the fact that there is death penalty. So would you say that this argument of deterrence or lack of deterrence cannot be given either by advocates or opponents of death penalty?
Okay. You see, I'm not saying that the deterrent principle has no value, but the deterrent principle doesn't work in cases of death penalty. First, we have given the reasons for that. First, there is empirical evidence in fact suggests that it has no deterrent effect. When you talk of deterrent effect, you have to assume so many things. You have to assume that when the accused person is about to commit a crime, he knows the sentence for that particular crime. He knows that there is a likelihood of he being given a death sentence, and he considers this possibility and still commits a crime, or he is deterred from committing a crime. It's simply a myth. It doesn't happen that way. Ordinarily the various theories show that ordinarily the instinct of the person who is about to enter into this criminal enterprise, he is to protect himself. I mean, he is not going to think about the punishments, etc. So it has no deterrent effect. And just consider how many death penalties are actually, how many people are executed in this country. I mean, it has become really symbolic.
Mm-hmm. But some would say that the very fact that there are very few executions or hangings that actually happen show that there is due process of law which is being followed, and only in cases where there is evidence beyond doubt and the judiciary is really convinced that that is the rarest of rare case, but is an execution ordered and carried out.
Do we want to retain the death penalty only as a symbol? Now just consider this. There is a complete, from 1950 we have considered the figures of the death penalty, and actually death penalty being enforced against the convicted accused. And we found that really in recent times, I mean, only in 4.7% of the cases, death penalty is actually confirmed by the Supreme Court. Now, the rest of these cases, 95% and odd, they are given death penalty or by the lower court or by the high court. Now just consider whether it's worthwhile. I mean, because those persons, 95% persons, they undergo the agony. They are on death row as death row prisoner, and it's a great agony for that person. It's considered.
But now
to be
hasn't a
inhuman.
time limit been set by the
No,
Supreme
that is
Court of
now
14 days between confirmation
No,
of
no, that's different.
death sentence and
The
execution?
Supreme Court said that if there is undue delay after in execution of the person who has been given death sentence, they carrying out the death sentence, then that would be violation of his human right. So in Shatrughan Chauhan and the other cases, for instance, the Rajiv Gandhi killers case,
Absolutely.
where the court said that there was undue delay in execution. Why it is said? Because it is considered to be cruel and degrading if a person is kept on the death row. So what is happening in India is almost for 15 years or 20 years the death penalty is not executed, and now the earlier view by the court was that the delay only after the that is the view of the Indian court, only after the all judicial remedies are over, that will be counted for the purpose of
only executive
commutation.
delay will be seen as delay and not judicial delay.
Not the judicial delay. But outside world, for instance, Privy Council, which had taken a different view earlier, has now taken a view that even that delay has to be explained.
But what about cases where there is hardly any time difference between the decision to execute, for example, the Yaqub Memon case and the hanging? There was the time lapse wasn't much, whereas the victims had to wait for 22 years for justice.
Therefore, what is the difference between what we argued that really there is no difference between the judicial delays and the executive delay. The principle, according to the Commission, is the same. We refer to all these cases. But apart from that, I just want to tell your viewers why it is considered that in heinous offences this death penalty is the only appropriate punishment.
Because some in the dissent note have asked what punishment would you give to the Nithari
That's
killers?
correct. Now we'll come to the alternates. I mean, for example, now in 140 countries, death penalty is not enforced. So what is the alternative to that? There is some misconception about it. I mean, these people feel that not giving death penalty is almost amounts to releasing him, which is not correct. Alternate to the death penalty is the life sentence. Again, there is a misconception that the life sentence means 14 years in prison and the convict would come out, which is not correct. The Supreme Court said that in Maruram's case, that the life sentence means life sentence for whole of the life till the prisoner breathes his last. But this is subject to the just remissions. Now, this is in some states in a heinous offence the convict will not be released till 30 years. 40 years, and in some states for certain offences.
But in the event of death penalty being abolished, Justice Shah, should remission be applicable for life convicts? Should they be allowed to go out on parole?
No, remission should be there, but there should be longer sentences. I mean, today the remissions are, I mean, in some states there might be some issue. Completely unjust to say that he should remain in jail for the whole of the life. I mean, but if the longer sentences serve that purpose, say a person has committed a heinous offence, say at the age of 30, and he spent some 30-35 years in prison, or maybe even longer than that. I mean, you really want to detain him in jail even after he attains 65 or 70? Is it not sufficient?
But if you think of from the perspective of the victim or the family, for example, Nirbhaya's mother has spoken out on this and has said that at least allow us, the option of seeing the killers or the rapists being hanged. And there are those who have said in the dissent note that what about the rights of the victims? Shouldn't they take precedence over the rights of the accused?
One by one. The first thing is that now, as I said, in several countries or large number of countries, death penalty was there, it is not there. Now, death penalty is on the statute book. So when you demand for the highest penalty, then it has to be death penalty. When the death penalty is done away with, in several countries, in Europe for example, entire Europe is free of death penalty. So if it is done away with, what is the highest penalty for the accused? Naturally the victim's demand would be that he should be put in prison for a long time. He should suffer for that. And naturally there has to be just punishment. The Commission is not opposed to just punishment. The Commission is opposed to the practice of carrying death executions, judicial executions. Now we come to the second point. What about the victim's rights? Now in this clamor of death penalty, which is awarded in few and handful of cases, for example, you are talking about Nirbhaya's case. What about the other, because that became a high profile cases. There are many similar cases of the rape and murder, more gruesome than Nirbhaya's case, and you will find, I mean, several judgments giving life sentence to the accused, or a longer sentence. For instance, very recently the Delhi High Court awarded 30 years in that case. Now leave aside that issue of sentence, it should be a long sentence. Is the view of the Commission that it will operate as a deterrent. Longer life sentences, or the life sentence is a deterrent, is not a less deterrent than the death penalty. But let us come to the issue of the present state of the criminal justice system. Where is the relief for the victims? Where is the rehabilitation, or where is the idea of restorative justice?
Which brings me to my next question. Should police reforms and changes in the investigative machinery precede abolition of death penalty? Because ultimately victims want closure.
You are looking at it completely in a because you are saying that the death penalty is something sacrosanct. It cannot be done away with. But at what cost? I am just pointing. My point is very different. At what cost you are doing it? Now look at the present state of the criminal justice system. The witnesses are routinely threatened. The investigations are faulty. There is no compensation to the or rehabilitation of the victim. There is no apart from anything else. What about the police reform? What the government has done about the police reforms? Why the Supreme Court judgment, which has been given, I think, in 2008, has not been implemented even after 7 years' time.
Okay.
So you should have a criminal justice system which investigates the crime efficiently, brings the accused to the book, he is tried quickly, and a just punishment is awarded to him. Would you like to have this kind of a system, or a system where there is as and when there is a high profile case, there is a clamor for the death penalty?
Just one last question, Justice Shah, on the death penalty, and that is that do you expect the report to be accepted? Because two government representatives, the Law Secretary, the Legislative Secretary, have submitted dissent notes besides Justice Usha Mehra.
No, of course, I mean, they were the members of the Commission. So really, as members of the Commission, I presume that they express their personal opinions, because the government's views cannot be reflected in the Law Commission's report. Law Commission is only a recommendatory body. But what you say is correct. That might be an indication that the government of the day may not accept. I mean, that's but our report is for posterity. We are not expecting that the report would be accepted as immediately, and the steps will be taken to see the events, recent events. There is a change in the mood of the nation. To some extent, I am not saying that the majority is in favor of abolition, but look at the developments. One, that Tripura, for example, a small state, but its assembly has abolished the death penalty. They passed a resolution that the death penalty should be, unanimous resolution that death penalty should be abolished.
Okay.
The political parties, certain political parties, they decided to argue for death, and there are two private members bill brought in the parliament for abolition of the death penalty. One is for moratorium.
Okay, so you are saying this is for posterity?
This is for posterity.
And it is the government's call after all.
I have something to say in the end about the public opinion, that the public opinion is in favor of retention. That is, normally it is argued. So this was the position in France when the death penalty was abolished. But those were great statesmen like de Gaulle and Robert Badinter, who was the Justice Minister. They took initiative and death penalty was abolished, and in spite of several efforts to bring it back, it was never passed. UK, there was a popular opinion was in favor of retention of the death penalty when it came to be abolished. But the government has to take a lead. Many years, say decades ago, it was impossible to even imagine that untouchability will be.
Okay, so you are saying it's wrong to presume that the public opinion in India wants retention of death penalty. Perhaps a debate should start now.
Yes,
after the Law Commission has submitted its report. A committee headed by you has also recommended that MAT not be imposed retrospectively on FIIs and FPIs. Do you think that as far as companies are concerned who do not have offices in India, should there be application of MAT on them as well?
Just let me give the background, because I have to explain few things here. The reference made to the committee was for FIIs or FPIs there. The issue was really because there were inconsistent judgments by the Advanced Ruling Authority, AAR. So AAR in Timken and Praxair in 2010 ruled that a foreign company which has no place of business or permanent establishment in India would not be liable to pay MAT. Then the situation was reversed in the judgment of Castleton, which takes a view that all foreign companies would be liable whether they have a place of business or PE in India. So we have given roughly, this is our first reason that Timken and Praxair were correctly decided. As far as because MAT would apply to a company which is governed by regulatory regime of the Companies Act. This was the view in Timken and Praxair also, and we agreed with that. It would apply only to those companies. If a foreign company which doesn't have a PE need not it is not covered by Companies Act, and it did not file their accounts in accordance with the Companies Act. So we said that those companies would not be covered by MAT.
In one line, if you could answer this, the government has said that they would go ahead with an amendment in the Income Tax Act in order to implement the recommendations that the committee headed by you have made. Is that the best way to settle the issue instead of a circular?
Yes,
like
Mr.
Mr.
Government
Jaitley
thought
put
it fit to settle this issue by bringing a legislative amendment. A simple clarificatory amendment will take care of that. We made two suggestions: either the CBDT should issue a circular, or the government should bring an amendment.
Okay.
And see that the government has decided to follow the second course of action.
Absolutely. It was a pleasure talking to you, Justice A.P. Shah,
well.
on Candid Conversation.
Thank you, Mona.
That's all that we have for you in this edition of Candid Conversation. Thanks for watching.